നമസ്കാരം. 2023-24 മാഗസിൻ കമ്മിറ്റിയുടെ നേതൃത്വത്തിൽ ഗവർണറിന്റെ അധികാര പരിധികൾ എന്ന വിഷയത്തിൽ സുപ്രീം കോടതിയിൽ നിന്നും റിട്ടയറായ ജസ്റ്റിസ് KM ജോസഫ് നമുക്ക് മുന്നിൽ ഒരു ഓൺലൈൻ ക്ലാസ്സിലൂടെ എന്തൊക്കെയാണ് കോൺസ്റ്റിറ്റ്യൂഷനിൽ അല്ലാതെ ഭരണഘടനയുമായി ബന്ധപ്പെട്ട് എന്തെല്ലാം വിഷയങ്ങളാണ് ഗവർണറുടെ അധികാര പരിധികളുമായി ബന്ധപ്പെട്ടിരിക്കുന്നത് എന്ന വിഷയത്തിൽ ക്ലാസ് എടുക്കുകയാണ്. അപ്പോൾ ഈ ഒരു ക്ലാസ്സിലേക്ക്, ഈ ഒരു ഓൺലൈൻ സെഷനിലേക്ക് ജസ്റ്റിസ് KM ജോസഫ് സാറിനെ ക്ഷണിക്കുകയാണ്. അതുപോലെ തന്നെ ഇനിയുള്ള നിമിഷങ്ങളിൽ ജോസഫ് സാർ നമുക്ക് മുന്നിൽ ഈ വിഷയത്തെ പറ്റിയുള്ള കാര്യങ്ങൾ നമുക്ക് വിശദീകരിച്ച് നൽകും എന്ന് വിശ്വസിച്ചുകൊണ്ട് സാറിനെ ക്ഷണിച്ചുകൊള്ളുന്നു.
ഓക്കെ, താങ്ക് യു. തുടങ്ങാമല്ലോ ഗോവിന്ദ്?
അതെ, തുടങ്ങാം സാർ, തുടങ്ങാം.
ഓക്കെ. I would start by going back a little bit in time. See, it was in the year 1858 that under the transfer of power to the Crown Act of 1858, that the affairs of the East India Company in relation to British India was taken over by the Crown in England. Thereafter, as you all know, we had the nationalist movement in 1885. The Congress was founded. Before that, actually in 1861, you had the first Councils Act, the kind of attempt at devolving power, in associating Indians with the British rule. You had a further improvement in 1892, and then we also had a much better version in 1909. Thereafter, you had the Government of India Act of 1919, which was followed up, as you know, by the immediate predecessor of the Constitution of India, namely the Government of India Act 1935. Now, the Government of India Act of 1919 and the Government of India Act of 1935 are relevant and important for the topic at hand, because both of them actually put in place a governor at the helm of affairs in the governor's provinces. Now, you must bear in mind that Travancore and Cochin, which were princely states, were not part of British India. They had their own princes, they had their own systems of government. But as far as British India was concerned, the acts actually conferred various amounts of power with the governors under both the acts. What is of particular relevance, just a few asides. In the 1935 Government of India Act, 75, Section 75 of the Government of India Act actually almost corresponds with Article 200 of the Constitution, which, as you know, provides for the need for assent by the governor to a bill which has been passed by the Legislative Assembly, or if there is an assembly and a council both. Now, Section 77 of the self-same act, namely the Government of India Act 1935, curiously provided for an overriding power with the Crown in England to reverse a law made by, at the level of the governor's provinces, or even at the central level with the assent of the Governor General, within a period of 12 months from the day of passing of the law. The Constituent Assembly, as you know, I'll straight away come to the Constitution now. The Constituent Assembly sat for 2 years, 11 months and 18 days, and they adopted the Constitution on the 26th of November 1949. It was provided therein itself that the Constitution would come into effect on the 26th of January 1950. So we became a sovereign democratic republic, because the words secular and socialist were not there in the original preamble. Now, why I have taken pains to draw your attention to the word democratic republic is of the is the link between the concept of democracy as we have adopted in India and the role of the governor. We also have Article 1 of the Constitution, which provides that India shall be a union of states. We keep saying that India is a federal state. The actual position in law is that actually it is not a full-fledged federation like the United States. I'll give just two circumstances which may detract from it being treated as a full-fledged federal federation. See, when the various provinces in British India, which are actually part of the British India, and they decided to join, they were not sovereign states like the states were when the Constitution was adopted in the United States. Sovereignty was never vested with the states within British India. No doubt there was sovereignty as far as the princely states, which are also like Travancore and Cochin, also joined in the Union of India through a process of negotiation, adjustments of rights. So I have brought up two concepts, namely India shall be a democratic republic, India shall be a federation or rather a quasi-federation. Another reason why it is not treated as a full-fledged federation is the existence of power with the president to bring about president's rule under Article 356, a concept which is wholly alien to the United States Constitution. A true federation would not make over such overwhelming, overriding power with the center, which is why in S.R. Bommai versus Union of India, 1994, 3 SCC page 1, it has been held that India is a case of a federation, but with a strong tilt towards the center. It can be described also as a quasi-federal republic. So it is a democracy and it is a quasi-federal republic. Now, where does the governor come in and how does he fit in? Because the relevance of the governor to India being a sovereign democratic republic and also a quasi-federal republic is that he has been recognized as a go-between between the center and the states. He is a link between the central government and the states. But at the same time, it is necessary to preserve the sovereignty of the states as we can understand with reference to its lawmaking powers under Article 245 and 246, read with the three lists we have in the seventh schedule. Now, the governor is actually a constitutional head of the executive. Once this idea slips into our minds, much of the misgivings about the true scope of the powers of the governor will dissolve. Much of the tensions that exist between the governor and the Council of Ministers will dissipate. I would urge you to fully read, not from here and there, the judgment of the Supreme Court in the decision reported in Shamsher Singh versus State of Punjab, 1974, volume 2 SEC, page 831. It was a bench of 7 judges. There were 4 judges who joined with Chief Justice Ray, who wrote the majority judgment. Justice V.R. Krishna Iyer for himself and for P.N. Bhagwati J. actually wrote a concurring judgment, agreeing with the majority judgment. What was the issue in that case? A probationer, or rather 2 probationers, their services came to be terminated. The order recited that the governor was pleased to terminate their services. The contention which was raised by the parties was that when you say that the governor has been pleased to terminate the services and having regard to the wording in the constitution, that the governor shall do this, governor shall do that, the governor must exercise his individual discretion in the matter of terminating the services of the probationer as well. This argument was repelled. Not only was this argument repelled, find if you read the whole judgment, an entire compendium of all the principles relating to this branch of constitutional law, namely that India has adopted the parliamentary democracy which is prevailing in England, which is why this Krishna Iyer in his characteristic style in one sentence he says, not the Potomac, which is a river as you know in Washington, but the Thames, which is again a river in London, which fertilizes the Yamuna by way of a riverine imagery, as his lordship says, which means that we don't have the presidential system, we have what is called the parliamentary democracy. Now, what is the hallmark of the parliamentary democracy? In a parliamentary democracy, the little man with the little piece of paper goes to the ballot box. Now we have the EVM. He puts his vote, exercises franchise. The representatives convene. And
സർ, സാറിന്റെ ഓഡിയോ മ്യൂട്ടാണ്.
നേരത്തെ പറഞ്ഞുകൂടായിരുന്നോ?
സോറി സർ.
ഇപ്പോഴാണോ?
അല്ല, ഇപ്പോഴാണ്. ജസ്റ്റ് ഒരു മിനിറ്റ് ആയത്, 30 സെക്കൻഡ്സ് ആയതേ ഉള്ളൂ.
ഓക്കെ, ഞാൻ അറിയാതെ തൊട്ടതായി. ഓക്കെ, ഞാൻ എവിടെയായിരുന്നു നിർത്തിയത്?
Sir, parliamentary system little man with a piece of paper exercises all the franchise.
So we have the cabinet, the council of ministers. Yes, I was at the council of ministers. Now the council of ministers actually is the seat of executive power in a parliamentary democracy such as we have in India. I began with the preamble democratic, but democracy is there in America also, but it follows the presidential system. We follow the British system, the parliamentary system, where the actual authority of the executive rests with the council of ministers. We say the government. Now it is into that we have to superimpose the persona of the governor. So we begin with how the governor is appointed. Article 155 of the Constitution. I hope you have the Barak to the Constitution with you. Article 155 provides for the appointment of the governor by the President of India. Now, in the Constituent Assembly debates, draft Article 131 corresponds with Article 155 of the actual Constitution we have. There were two models for the purposes of actually selecting or appointing the governor, which was contained in draft Article 131. The first model provided for election by all the members of the electorate of that state. So the governor was contemplated to be as an elected representative. The second model was that members of the Legislative Assembly of the states would elect 4 persons. A panel of 4 would be sent to the president, and he was free to choose from any one of them. Now, both these models involved exercise of the franchise by the electorate. Dr. Ambedkar points out that it is going to be a very costly affair. Secondly, there was another objection also. You would have a conflict of power because the chief minister and the governor, if both of them are elected, each of them would vie for having greater power with them. And this could lead to a kind of a breakdown in the administration of the state. So both these models were given up. And what is relevant is what Dr. Ambedkar says. If you would go into the Constituent Assembly debate, what Dr. Ambedkar actually pointed out was, please bear in mind the actual role and the functions of the governor whether he is elected, whether he is nominated, his role is only as the constitutional head. He is nothing more, nothing less. Call him a figurehead may not be fully correct because he does have some role to play, like the president. But beyond that, he is not the source or the seat of executive power. I really wish all governors who are appointed would bear this fundamental principle in mind. They are not elected, which was the proposal actually in the Constituent Assembly. Instead, they are nominated. Now, this is at the root of the misgivings that people have about the governor as a head of the state, but he is only head in a nominal or in a constitutional sense. Um, in fact, we have had three commissions, as you know. The first commission was necessitated somewhere in 1983. The Sarkaria, R.S. Sarkaria, former judge of the Supreme Court, was appointed as Sarkaria Commission to go into center state relations. You must imagine, you may imagine, that is within 33 years of the founding of our republic, things had come to such a state of affairs that there were a huge number of complaints raised by the states against the way the governors were being appointed, the way they were functioning. So one of the aspects which was considered by the Sarkaria Commission was in fact the very need to have a governor and other complaints relating to specific aspects and instances of their functioning. It gave a report, and as far as the appointment of the governor, another aspect which you should bear in mind is that the qualifications for being appointed as a governor is provided in Article 156. It only says a person who is 35 years of age and who is a citizen of India can be appointed. Now, this means there is such a wide latitude with the president, means the Council of Ministers at the center, to pick and choose. Now, usually what would happen is that that's a huge politicization. Political parties would be full of people whom they could not fit in with other assignments. So they would, okay, mollify them, accommodate them as governors. But it was the Sarkaria Commission which actually pointed out that they should possess certain qualifications, like they should be eminent in some walk of life. They should be detached. They should not be associated, dabbling in politics for at least 2 years, as later in the Punji Committee report it has been made out. These four things were actually mentioned in the Sarkaria Commission. It has been reiterated in the judgment of the Supreme Court in the case from Bihar, which you will get in the year reported in the year 2006. So you may take it that the actual contemplation of the constitution, the founding fathers, as now percolated down to the judgments of the Supreme Court and the commission is that he must be an eminent person. He must not indulge in politics. He should not take an active part in politics even for 2 years at least prior to his being appointed. Now, another recommendation which has been made is that Punji Committee has made this recommendation for the amendment of the Constitution in Article 156 that he should be selected by the Prime Minister, the Speaker, the Vice President, and the Chief Minister of the concerned state. So always, in fact, the Chief Minister, the states, it was called the province states' interests were to be taken into consideration. In fact, if you go to the Constituent Assembly debates, P.T. Krishnamachari, one of the eminent members of the Constituent Assembly, has in a speech said that what is contemplated is that the president would actually go by the opinion of the chief minister and not have somebody who's not acceptable to the chief minister. So all these were actually said, but then when it came to actual practice, we have the provision Article 155 and 156. And the way it is being done, you all know, I do not have to say anything further. Now, then what is the term of a governor? The term of a governor is that he is appointed for a period of 5 years. This is ordinary, but it is subject to the overriding clause that he will continue in office during the pleasure of the president. Now, the expression pleasure of the president or of the governor, you'll find in Article 310(11) also. The Supreme Court had occasion to consider the scope of the provision relating tenure in the judgment which is reported in. Just give you the That was a case of a public interest litigation filed under Article 32 of the Constitution, challenging the removal of 4 governors. The court, even though it became infructuous in the sense that the facts it became infructuous, the court decided that the Constitution bench has proceeded to actually make very important observations, findings about the true position of the governor. I'll just give you the reference before that. This is BP single versus Union. Okay, please look it up. Now, what has been said there is very, very important again for all governors to bear in mind. The Supreme Court has held that the governor is not an employee of the central government. He holds a high constitutional office, like a Supreme Court judge, or any of the constitutional office holders are not really employees. They are not, again, the Supreme Court says in BP single, that they are not amenable to the directions of the government of India. They hold independent constitutional office, not subject to the control of the government of India. Again, the Supreme Court lays down they are not agents of the government of India. They have a dual role as the constitutional head of the state and a vital link. The second role is as a vital link between the center and the states. They owe allegiance only to the Constitution of India and not to the government or the political party which appointed them. They cannot be politically active. Please bear in mind these very, very pertinent observations. Because very often there are accusations that the governors actually act as agents, employees, just implementing a plan. In fact, this is Krishna Iyer's concurring judgment. He uses the expression remote control in 1974, just 24 years after the Republic came to being. Things have even become worse, as you all know. Now, the Supreme Court dealing with the question, which was whether it could be removed at pleasure when the government changed, and you have a new government in place which did not appoint him, and they're not happy with him, and they actually order them unceremoniously being dismissed on the basis of the doctrine of pleasure, which is embodied in Article 157. The court said the petitioners were not right in contending that the doctrine of pleasure, which of course it is not a feudal doctrine of pleasure in England, which Supreme Court accepted. But the Supreme Court said, nonetheless, a governor can be removed at any time, even before he completes 5 years. The only qualification was, if it is challenged in the court of law, then the court would ask the government, central government, to defend its action and to make available the records and to come forth with the reasons or the materials which prompted the government to actually bring the tenure to a premature end. If it is found that there are no reasons or that the reasons are irrelevant, arbitrary, mala fide, whimsical, then the court declared that the court will not hesitate to interfere with the premature termination of the tenure of the governor. But what is important is, on the one hand, the court wanted to protect the governors from, punitive, action, which is kind of a revenge that you were an appointee of another political organization. So the moment we come in, we throw you out. At the same time, the court was careful to lay down the overarching principles which should govern us in the matter of their approach to what they can do and what they cannot do. See, the problem in constitutional law, as in any other branch of law, but mostly in constitutional law, is that each constitutional center power must first ask the question as to what is the sphere of my authority. Within what circumscription can I work? What are my powers? More importantly, what are my limitations? If you are humble enough, deferential enough to understand that I cannot do X, Y, Z, most of the problems we face in the matter of tension between the governors and state governments would dissipate. Now, having spoken about the appointment and the tenure, we come to the more important question as to the nature of the powers. The nature of the powers, you must read 3 articles in tandem. Article 154, Article 163, and Article 166. The Article 154, as you all know, actually provides that the governor shall be the head of the executive. I have already explained that the governor is not the head of the actual executive in the sense that he is not the seat of power. The seat of power is the government represented by the Council of Ministers. No, it's important that I just read out Article 154. I hope you have that with you. The executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to accordance with the Constitution. Now, Article 163, which I mentioned, comes under the heading Council of Ministers. It says, there shall be a Council of Ministers with a Chief Minister at the head to aid and advise the governor in the exercise of his function. Now, the next words are very important. They have been the source of so much of tension, except insofar as he is by or under this Constitution required to exercise his functions or any of them in his discretion. Sub-Article 2, of course, goes on to say that the governor's decision as to whether he has acted in his discretion is final, and that the advice given by the Council of Ministers cannot be accepted or gone into by the courts. Article 166 indicates all executive action of the government of a state shall be expressed to be taken in the name of the governor. And sub-article 3 is very important. The governor shall make rules for the more convenient transaction of the business of the state and for allocation among the ministers of the said business insofar as it is not business with respect to which the governor is or by the Constitution required to act in his discretion. I wanted you to read all these 3 articles together because there is a golden thread running through all these articles. And that is that the governor is only a constitutional head. He is advised, aided by the Council of Ministers who are elected representatives. And the advice is binding. The advice given by the Council of Ministers is binding on the governor. Actions of the state are expressed to be taken in the name of the governor. No, the courts have held the given case with this challenge. The fact that it is not so expressed may not by itself vitiate the action, is always open to the government to explain and establish that it was indeed taken in accordance with that. It is here that we must read Article 166(3), which provides for rules of business, which you know. Rules of business framed by all state governments. But when the rules of business they are really not statutory. In fact, they cannot trump over statutory or other rules or laws made. They are for the convenient transaction of government businesses. What does the rules do? Conduct of business rules framed. What do? They actually distribute work among the cabinet. Some decisions have been taken by the cabinet, full cabinet. Some decisions have been taken by the minister. Some decisions can be taken by subordinate officers. Now, the Supreme Court has held in Shamsher Singh that when a decision is taken by an officer or by the minister, it is actually the decision of the governor. It is expressed to be taken in the name of the governor. So this is a scheme for convenient carrying out of the business. But this does not detract from the fact that the governor is only a constitutional head. He is always bound to act in aid, advice of the Council of Ministers. Now here I may just bring in a refrain. Article 167 of the Constitution provides that it shall be the duty of the Chief Minister of each state to communicate to the governor of the state all decisions of the Council of Ministers relating to the administration of the affairs of the state and proposals for legislation. To furnish such information relating to the administration of the affairs of the state and proposal for legislation as the governor may call for. If the governor so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. The sum and substance of Article 167 is to actually epitomize the figure of the governor, that is actually an elderly statesman, a link between the center and the state. The idea of the founding fathers is that you have somebody as a formal constitutional head, but who is entitled to aid, warn, and even ask the government to reconsider any decision. If you go through judgments, I don't want to take time here, but it is settled. Like the president, the governor also has a right to ask the government to reconsider any decision, to warn that, see, this decision is not correct, this is not legal, not wise, against the interests of the people. Because you must realize that most governors rely upon the oath they are to take under the Constitution, which inter alia provides that they shall defend the Constitution and act for securing the welfare of the people. So they would always say, we are defending the Constitution. So please don't do that. Don't do this. This is part of the statesman character of the governor. It's always so in England also. We have borrowed the English model, I have already said. The Queen or the King could always ask the Council of Ministers, please look into it. Doesn't appear to be good. Doesn't appear to be in accordance with the law. But the important thing is, once the cabinet sticks by its decision, then the governor is bound to act in accordance. Now, once this is also put by, we go back to Article 163, the latter part of Article 163(1). I said, except insofar as he is by the Constitution required to act in his discretion. Now, the Supreme Court has culled out, in Shamsher Singh's case, a number of provisions in the Constitution itself, which specifically declare that the governor will act according to his discretion or his individual judgment. They are mostly to be found in Article 371A onwards, which, as you know, relate to the powers of the governor appointed for the northeastern states. The autonomous regions are also governed by the 6th schedule to the Constitution. If you just see para 9.3 of the 6th schedule to the Constitution, even though 18.3 also was there, it has been repealed. But para 9.3 specifically confers power on the governor in the autonomous regions to exercise his individual judgment, because the reason, the geography, the history of that region required vesting of the power with the governor, of course, subject to the overarching overriding power of the president, which means the central government. So the Supreme Court held that it is in respect of these specific express provisions of the Constitution which confer discretionary power on the governor, that the latter part of Articles 1631 is attractive. Save in respect of those articles, the governor, in other words, was bound to exercise his powers, going by the aid and the advice given by the Council of Ministers. Now, the question would arise as to whether there are any implied restrictions on the Council of Ministers or authority derived by the Constitution, by the governor, apart from these express provisions. The Supreme Court has enumerated a few of them. If you read the declaration by Justice Krishna about the law of the land in his concurring judgment, I will just start with that. The choice of the chief minister. See, when an election is held and members are elected, as you know, they will stake a claim for forming the government. There is no government at that stage. So the governor will have to exercise his discretion, but it is constitutional in the sense it is conditioned by the principle that he will choose only the candidate which can command the majority in the House. So that is a basic democratic principle. The Supreme Court has laid down in a catena of decisions following also Sarkaria Commission the manner of choosing. I would advise you to look up those judgments, which include Shamsher Singh, which lay down, it's a nitty-gritty of it. I mean, I won't be taking time. But this is one of those discretionary powers of the governor, apart from the express provision which I have already referred to, which has been called out in Shamsher Singh. The next is a dismissal of the chief minister. Now, you see, following the principle that the chief minister can hold office, the ministers can hold office only as long as they command the majority in the House of the people, which means in Kerala, for example, it is the Legislative Assembly. In a case where it is found, the governor is of the view, he finds material to suggest that here is a Council of Ministers which has lost its mandate in the House. Now, he is bound to quit. Now, if he doesn't quit, and if he doesn't take a float test, actually the governor should hold a float test if there is any dispute. And if at the float test, if he succeeds, fine. Otherwise, the governor can dismiss. This is again one of the discretionary powers. You won't find all this expressly in the Constitution, but these are all constitutional conventions, which is actually borrowed from England, transplanted into our land from since long. Then there is also the aspect of dissolution of a government which has lost its majority. Then again, we go by the float test and after exploring other possibilities. Now, another area where the governor would have discretion, which is not directly traced to any express provision of the Constitution, is in the matter of granting sanction for prosecuting a chief minister or ministers. Now, you know that ministers get, accused with having committed crimes. Now, sanction for prosecuting them is a legal necessity under the provisions of the Code of Procedure Code and also other laws. It may happen that, for example, if the chief minister, he may naturally not want to be prosecuted. So the aid and advice that he will give to the governor in the matter of this file relating to sanction is that please don't give sanction. Equally, in the case of other ministers, they would also have sufficient pull and pressure brought on the other ministers, including the chief minister, to see that the advice given by the Council of Ministers is that don't give sanction. So what is the governor to do? This is not a matter which comes under any express provision conferring discretion on the governor. But the Supreme Court has laid down that these are both namely chief minister and ministers getting involved in crimes, and prima facie there is huge material available for prosecuting him, then in the matter of sanction, it has been held by the Supreme Court in the judgment reported by Constitution Bench 2004, Volume 8, SCC, page 788, Madhya Pradesh Special Police Establishment case. The said case also refers to an earlier case, that is Nayak's case, which actually related to the chief minister. This particular case related to the ministers. You may take it as settled, therefore, that one of the exceptions in which the governor has a discretionary power, apart from express provisions, as I have already indicated, which are there in the Constitution, is question comes up whether the government should give sanction for prosecuting the chief minister or the ministers. In 1997, Volume 2, SCC, page 775, the court was concerned with the exercise of powers which were vested in a governor in a statute in the matter of administration of a shrine. The court held that when a statutory power is conferred on a person who is also holding the post of the governor, he need not act in accordance with the aid and advice of the governor. I mean, of the Council of Ministers. He is free to act in accordance with the statutory discretion with the statutory authority, as you all know, how he is expected to act. Call it the Wednesbury principle, where you eschew irrelevant facts, take into consideration relevant facts, you don't act mala fide, you apply your mind, and you comply with natural justice wherever it is required. You come to a decision. So that is what statute. Now, the same principle, as you know, is applicable when a governor is appointed as the chancellor of a university. There also, he is not bound to act in accordance with the aid and advice of the Council of Ministers. Now, the governor sends what is called fortnightly reports. Every 2 weeks, he sends reports about the way the affairs of the state are being conducted by the state government to the central government. Now, this is a convention. It has been going on for a long. Actually, a copy of it is also sent to the state government. The Supreme Court has approved of this practice, even though, again, it is not to be done, obviously, on the aid and advice, because here is a matter where he'll have to exercise his own individual judgment and discretion, because this may lead, finally, to appropriate action being taken under the Constitution of a greater magnitude, graver magnitude. The Supreme Court has approved of this practice, saying that it promotes transparency and better administration. Now, there is another provision of the greatest importance, which is Article 356 of the Constitution. 356 of the Constitution, as you know, provides for proclamation of President's rule when a report is sent by the governor or otherwise the central government is satisfied that there has been a breakdown of the law and order, breakdown of the condition, the constitutional machinery is broken down, cannot be conducted, affairs of the state cannot be conducted in accordance with the Constitution. You know that in the early periods, that is after immediately after, the same government, same party was in power in the center and the states till about 1967, 1969, where different parties, formations, coalitions came to power in the states and different from the party which was occupying. So you had a huge number of actions taken under Article 356, led to a lot of abuse. But of late, it has come down. But suffice it to notice that even in the judgment in Shamsher Singh's case, the Supreme Court has flagged Article 356 as a situation where the report to be sent by the governor is not to be prepared on the basis of the aid and advice of the Council of Ministers, for obvious reason that it is going to be adverse to the government if such a condition exists. So the governor should be completely free to report to the central government that a situation has arisen where there has been a veritable breakdown of the constitutional machinery. Now, if it's going to be on the basis of the aid and advice, the state government is never going to advise the governor to make such a report. So here is another situation not covered by an express provision, But by the setting of the article, the objects ought to be achieved. That Supreme Court has accepted that the governor would have to act according to his discretion. Article 192 of the Constitution is another article which provides for the governor's power to rule on disqualification of a member. Now, in the article, it specifically says that the governor shall take a decision, but it also says that it shall consult the election commission. Now, when it comes to Article 192, the governor is free not to look to the advice of the Council of Ministers, but to act only and only exclusively based on the opinion given by the election commission, because that is how it is chosen. So these are some of the the areas where the governors have independent powers to act in the matter. Now you come to some of the other aspects of the executive power or the true position of a governor as a constitutional head. If you see Article 174 of the Constitution, it speaks about, what does it speak about? Would anyone venture to tell me? Okay. Sessions of the state legislature, prorogation, dissolution. The governor shall from time to time summon the house. So you would think that the governor means the governor can act in his discretion. This has engaged the attention of the Supreme Court, and a lot of politics has been played. And in these matters, the governors have thought it fit that they can call sessions of the legislative assemblies without there being aid and advice of the Council of Ministers. This has led to a lot of pandemonium. I would request you to read the judgment of the Supreme Court in Naba Rebia, namely 2017, volume 13 SEC, page 332. In the said case, all of it took place in the state of Assam. A lot of convoluted set of facts, but the nitty-gritty of it was that on acting on the basis of the aid and advice, the session was scheduled to meet on a particular day. The governor, who in fact was accused of being politically aligned with obviously the center and the parties in the state owing allegiance to the same party, decided to prepone the assembly. And he also sent a message. Now, the word message, is to be found in Article 175, the right to the governor to address and send messages. Both these powers, it was held in Nabia, could not be exercised unless and until the governor was advised. So you may bear in mind that whenever the governor does something, it is always with the support of the aid and advice, unless it is a matter which actually falls within the realm of his discretion or individual judgment. In a recent judgment, in fact, arising from the state of Punjab, things became even more cramped, actually. I mean, more complicated. It is a decision which was actually rendered on 2023. I do not have the citation, but you can look up State of Punjab versus Secretary to Governor. The governor sought information within the meaning of Article 167 of the Constitution, which I have already told you, that it is always open to the governor to seek information. And it is a duty of the Chief Minister to provide the information. Chief Minister is also a constitutional authority. The Supreme Court had to then deal with a situation where, alleging that the Chief Minister had not provided the information sought by the governor, and also pointing out certain other illegalities, refused to call the budget session, even though advice was clearly given to do so. The Supreme Court said both the governor and the Chief Minister are high constitutional authorities. They must act hand in hand, in harmony, so that constitutional goals may be achieved. And it was categorically observed that the fact that the chief minister did not positively respond to the request for information by the governor did not justify the governor in refusing, on the ground that he was actually awaiting legal advice as to what is to be done. And he would not call the assembly and the session of the assembly, though requested for, and though on the basis of the aid and advice. Supreme Court deprecated this practice. Therefore, the governor, in the matter of calling sessions, in the matter of address, in the matter of sending messages, are all bound by the aid and the advice. In this context, I would think it appropriate to point out that the governors do not read out the address, the message, policy statements, or just read a small little portion and then abruptly end. I would draw your attention to the judgment of the Supreme Court in 1979, 3 SCC page 324. I'll repeat, 1979, 3 SCC page 324. At paragraph 21, it says, I will read out, please read paragraph 21. The function assigned to the governor under 176, Article 176, as you know, speaks about special interest by the governor. At the commencement of the first session of each year is strictly not a legislative function. This is a constitution bench judgment. But the object of this address is to acquaint the members of the houses with the policies and programs of the government. It is really a policy statement prepared by the Council of Ministers, which the governor has to read out. I am repeating, it is really a policy statement prepared by the Council of Ministers, which the governor has to read out. So, the governors would be, in fact, well advised to bear in mind their actual position, to be subservient not to any person, but to the Constitution and the institution of governorship and what it really means, which in substance unfolds as a titular head and not a real source of power. When he reads out a statement, he knows that he is not actually reading out his opinion. He is but reading out the statement of the government of which he is a head, constitutional head, which in my humble view, going by the judgment, he is bound to read out and not parts of it, or as if it is it's some kind of idle formality. It is a constitutional, it is a requirement which is the Constitution bench has clearly declared should be done. And if you are very, very cryptic, short in the matter of reading out a long statement, it may not do justice, as it would be the interest of every government to proclaim to the whole world what the policy statement. It may, of course, be laid in the table of the House. It may be available, but these are all ceremonies. The Queen or the King in England reads out. So you may probably not have to read the whole of it cover to cover, but the substantial portion is what I would think is what is required to be done. Now, you come to the various other the powers which are vested with the governor, including so-called legislative powers. Article 213, corresponding with Article 123 for the central government, provides the state or the governor with the power to issue ordinance, which, as you know, is emergency legislation. When houses are not in session, a law is to be made urgently. Again, the words are the governor, but it is settled law. You can read some tracing that this power also can only be exercised on the basis of the aid and advice of the governor. So almost every other power, which except those which I have specifically indicated, has to be exercised by the governor, acting on the basis of the aid and advice of the Council of Ministers, in whom the power is, and actually who take the responsibility. Because if what they are doing is wrong, they'll be voted out in the next election, or they may be voted out immediately. If the configuration is such that political parties align and if they're actually shown the door, therefore there is accountability. The governor is unelected, he does not have any accountability as such, because he's only doing it on behalf of the government. Of course, again, this is subject to, I have already said, his well-known power to warn, to advise, to reconsider any advice. But here again, I would like to point out, see, in the guise of exercising these powers or duties as they are called, the governor should not keep matters pending for a long period of time. The administration has to be run smoothly. Decisions have to be taken in time. So if governors actually, with perhaps being remote controlled, in the words of the Supreme Court, or actually liaising with the party in power at the center, it's all right if the governor actually meets delegations, but as the Supreme Court has held, he will not indulge in any kind of active politics. He will not be interested in the nitty-gritties of the politics of the state. He is not an agent. Again, I'm repeating, he's not an agent. He's not an employee. He will not act on the behest of the central government. He will not lend his ears openly or secretly. This is the constitutional position that a governor is expected to occupy, the functions that he is obliged to perform under the Constitution. Now, there is this important and controversial aspect relating to the assent to the bills passed by the Legislative Assembly. This is a matter which is governed by Article 200 of the Constitution. I do not know whether you have the Constitution, but I'll just read it because this is of the greatest importance and of topical importance also. When a bill has been passed by the Legislative Assembly of a state, or in a case of a state having a legislative council has been passed by both houses of the legislature of the state, it shall be presented to the governor, and the governor shall declare either that he assents to the bill, or that he withholds assent therefrom, or that he reserves the bill for the consideration of the president. The first proviso, there are two provisos. The first proviso actually provides that the governor, provided that the governor may, as soon as possible, after presentation to the bill for assent, return the bill if it is not a money bill. So if it is a money bill which has been defined in Article 199, together with a message requesting that the House or the Houses will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing such other amendments as he may recommend in his message. And when a bill is returned, the House or the Houses shall reconsider the bill accordingly, and if the bill is passed again by the House or Houses with or without amendment and presented to the governor for assent, the governor shall not withhold assent therefrom. The remaining portion of the article is the second proviso. It provides, provided further that the governor shall not assent to, but shall reserve for the consideration of the president any bill which, in the opinion of the governor, would, if it became law, so derogate from the powers of the High Court as to endanger the position which that court is by this Constitution required to fill. Now, therefore, if you read Article 200, you must realize, bear in mind, that the governor is a part of the legislature, because the Constitution declares that the legislature of the Legislative Assembly will consist of the governor and the Legislative Assembly, where you have only one Legislative Assembly, and the Legislative Assembly and the Legislative Council in 8 or 9 states which have legislative councils. Now, he cannot vote. The governor cannot vote. He's, as I said, he's only a titular head. He cannot participate in the proceedings of the assembly except he comes there and gives a message, reads out the message, and then this is all ceremonial. In the matter of sending message, also I have pointed out to you, it is governed by aid and advice of the Council of Ministers. Even though he is a member, since he is a member of the Legislative Assembly, the founding fathers have contemplated that the assent of the president is a prerequisite for a bill to blossom into a law. A bill does not become law. The moment the bill is passed, as you know, it does not become law. Assent of the president is absolutely an indispensable requirement to make it law. Even as you know, and that's just an aside, even if it becomes law in the case of a conditional legislation, which means that if it is laid down in the law, that it will come into effect on such day as the executive, the central government or what, brings out a notification. The mere passage of the law, you must always look up when you are dealing with laws. There is always one of the earliest provisions in an act will be, this shall come into force on such day as it comes. For example, the late three laws, criminal laws which were introduced in Parliament, they did not become law immediately on the assent being given by the president. But I think they are coming into force from tomorrow. This is my information. So that is conditional legislation. Now, when the president gives the governor has to therefore decide, give the assent. He can withhold the assent. There are, in my view, 4 things that he can do. One is he can give assent. Second, he can withhold assent. Third, he can reserve the bill for the consideration by the president. The 4th category would be he can return a bill which is presented to him for reconsideration with or without amendments, suggestions, and the House is bound to consider it. But the first proviso makes it clear, once the bill after reconsideration by the Assembly is again passed, with or without amendments, the governor cannot withhold assent, he is bound to give assent. So this is what I said I would have thought. Now, there have been judgments which I would like you to read in an academic exercise on this aspect of the region of the law, namely 1952. That is a famous Kameshwar Singh case. 1952, 1 SCC 528 at paragraph 235. Now, this has been followed also. This particular paragraph, what has been said, has been followed in 1979, 3 SCC, page 324. So, since it has been followed in 79, 2 SCC, 324, paragraph 19, I will just read out to you for a particular reason the said provision, the said paragraph. The paragraph 19 of 1979, 3 SCC 324. The governor is, however, made a component part of the legislature of a state under Article 168, because every bill passed by the state legislature has to be reserved for the assent under Article 200. Under that article, the governor can adopt one of the 3 courses. Namely, he may give his assent to it, in which case the bill becomes law. Or he may, except in the case of a money bill, withhold his assent therefrom, in which case the bill falls through, unless the procedure indicated in the first proviso is followed. That is, return the bill to the assembly for reconsideration with a message, etc. Now, this judgment, you may bear in mind, and why I say this is, the issue relating to assent has also been considered in 2 judgments which are of recent origin. One of which is Nabia, in 1974, 2 SCC page 831, that is the celebrated judgment in Shamsher Singh case also. Now, what have the Learned judges laid down there? As I said, there was a majority judgment and a concurring judgment. You will see the view of the majority judgment in regard to the question of assent and Article 200, expressed in paragraph 56 of the judgment of Chief Justice Ray. I'll just read it, just two sentences. Similarly, Article 200 indicates another instance where the governor may act irrespective of any advice from the governor, from the Council of Ministers, in such matters where the governor is to exercise his discretion. He must discharge his duties to the best of his judgment. The governor is required to pursue such courses which are not detrimental to the state. Now, in the concurring judgment of Justice Krishna, speaking on behalf of Justice Bhagwati also, you will find their views expressed in paragraphs 123 and 124. I will refer to it in detail at a later stage for, again, reasons which I will make clear. Now, the question arose also, as I said, in Nabam Rabia 2017-13 SEC, page 332. And there, again, it was a constitution bench. The constitution bench has referred to this question of assent as referred to the Poonchi committee on assent on the question, because Poonchi committee has also expressed its views in regard to assent. In fact, what the Poonchi committee has recommended is to do away with the clause in Article 200 which permits the governor to withhold assent. Namely, he cannot withhold assent. That is what Poonchi committee has recommended. The Poonchi committee has also, in fact, further recommended that the provision for reserving a bill for the assent of the president should be done away with, except in a situation which is governed by the second proviso, namely if a bill proposed by the state legislature which is passed has the effect of detracting from the authority of a high court within the meaning of the second proviso. Apart from that, the Poonchi committee also said it should be done away with. Now, please also look up AR 2019 Supreme Court page 2973, which is BK Pavitra number 2. There are two earlier BK Pavitra. It related to the question of reservation for in the matter of employment, and the bill was referred to the reserve for the assent of the president. And this one of the issues which was dealt with by the court was the issue of the ambit of scope of Article 200. There, the court, in fact, refers to Nabam Rabia. The court also speaks about the core principle in Article 200 of the Constitution, being that Article 200 is a source of power for the president to reserve a bill for the assent of the president. Article 254, 2. Article 254, as you know, speaks about a situation where tracing their authority to list 3 of the Constitution, which, as you know, it contains a concurrent list. Both the central parliament, the parliament and the state legislatures have power to make laws. That is what is list 3 or the concurrent list. If there is a conflict between laws made by the state legislature and the parliament, in short, Article 254 declares unequivocally that the law made by the parliament, whether it is before the law made by the state legislature or after, will prevail. Article 254(2) provides for an exception, and the exception lies in a situation where the bill which is passed by the law which is passed by the state legislature is traceable to the concurrent list, and it is in conflict with a central law, and the law receives the assent not of the governor but of the president. Then Article 254(2) declares that the law passed by the state legislature, even if it is in conflict with the law made by Parliament, will have effect within the state, because the state has only power to make laws and territory within of its territory, unlike Parliament. So this is what Article 254(2) is, reserving for the assent of the President. President gives the assent that law made by the state will prevail in that state, even if it is found to be in collision with the law made by Parliament. So the Supreme Court in B.K. Pavitra declared that the provision in Article 254(2) is an illustration of a situation where a governor can reserve a bill for the assent of the President. But the court also said it is not exhaustive. In other words, Article 254(2) is only one instance where a bill may be reserved for the assent of the President. The court went on to declare that there is a discretion with the governor, and as to whether the discretion should be exercised in accordance with the advice again of the Council of Ministers, the court refers to Nabam Asiya Rabia, which I have given you the citation. You can go through that, and the matter was left there. In a recent judgment, and this is of the greatest importance, it arose again from the state of Punjab, and this is dated, I do not have the citation, but it's 10/11/2023. You can find out from the date. State of Punjab versus Governor. This is actually a sequel to the earlier judgment which I have told you, which took place in March, where the governor refused to call the session of the Punjab legislature, citing non-compliance with the request made in Article 167 for information, and also making certain other allegations and stating that he was awaiting the advice as to whether the matter should be called. The court came down and said, you can't be doing this. So in the second case with which we are now concerned, the Supreme Court had to deal with a case where several bills were kept pending. The governor was not acting on the bills. It was of the greatest importance for the state that the bills were passed, which can be done only, were ascended to, only then it could become law. So there, in the connection with that, the Supreme Court declared the law under Article 200 to be that there are three courses open to the governor. He can declare assent, means give assent. He can withhold assent, means deny assent. Or he can reserve it for the consideration of the matter by the President, which again, as you will recall, not limited by Article 254(2). There can be situations. This is what was held in the B.K. Pavitra. The court went on to find that in case the governor withholds assent, one of the three things that he can do, then he is duty bound to follow the regimen in the first proviso, which is that he must immediately, because the words used are as soon as may be, if you see the first proviso. So that is also a reminder, because there's another order which came from Telangana, which was a short order where the court emphasized the importance of the words as soon as may be. In also the cases from Kerala and from Tamil Nadu, again, the court kept on saying that this is the regimen, that no governor can inordinately delay action on the bills which have been passed. He must take a decision at the earliest on the bills, either by giving assent, denying assent, or reserving it for the president. The most important thing, however, is that the court held that if he declines the assent, he cannot just leave it there and the bill falls through. I will use the expression falls through with a definite purpose. I read out 1979 3 SEC 324 paragraph 19. The Supreme Court there, which is in fact a constitution bench, has used the words that if assent is declined, the bill will fall through. Whereas in the later judgment of the Punjab, the court has held that you cannot kill a bill by declining assent and just taking no further action, because that would render the governor a super legislature sitting over the action, legislative action of the legislature, and which is the proper constitutional forum for taking a decision as to what kind of laws it must be making. So it has to go back to the governor under the first proviso. Now, if it is sent under the under the first proviso to the to the legislature, you know what will happen, or rather, what can happen. If it is again passed with or without amendments, the governor is bound to give assent. So, in this way, the Supreme Court, by adopting this interpretation, has sort of helped promoted the democratic institutions and also, importantly, federalism, quasi-federalism, even if you call it, federalism to succeed. Otherwise, if a governor wishes, he can simply decline assent and keep it in his pocket. He said, I have declined assent. That's it. Now, I am only saying another thing. And now I will hearken you back to the concurring judgment of Justice Krishna Iyer, just for an academic debate. If you read paragraph 124 of the judgment in Shamsher Singh, which contains the concurring judgment of Justice Krishna Iyer and Justice Bhagwati, you will see the substance of it. I will say, I would ask you to read it. What Justice Krishna Iyer has said is that in the case of the Hindu Bill of 1951, you know, the code, Hindu Bill, we have the 1956 3-4 acts relating to Hindu succession, marriage, guardianship, etc. In regard to the Hindu code, the President Rajendra Prasad, was not inclined to give assent to the bills. He had his own views. So he wrote to the Attorney General, what am I to do? So the Attorney General wrote back saying that you are bound. More importantly, Sir Allada Krishnaswamy Iyer, who is referred to in para 124, one of the foremost doyens of the bar and a member of the Constituent Assembly, his opinion was also sought. His opinion has been set out in paragraph 124. Now, he says that in the matter of giving assent, withholding assent, and sending it for presidential consideration, the governor is again discharging an executive function only as a constitutional head, and he is bound by the aid and advice which is given by the Council of Ministers. So, if the Council of Ministers say, give assent, the president, the governor is bound to give assent. But is that so? If you read the later judgment, the question may arise, if it falls within the ambit of the second proviso, namely if the law, if it is passed, will detract from the authority of the High Court, then the Constitution itself declares that it shall be referred to the president. So that is one situation where even if an advice is given by the Council of Ministers, the governor may not be bound by the advice. Now, in a case where it is not falling within the second proviso, a question may arise if one looks at the law as laid down by Justice Krishna Iyer in the concurring judgment. In fact, I would think that the judgments, both by Chief Justice Ray, the majority judgment at paragraph 56, and also the judgment of the concurring judges in paragraph 123 and 124 of Shamsher Singh, has not perhaps been considered either in Nabia Hassan or the BK Pavitra and in the latest Punjab case. But as far as I'm concerned, I can only tell you that because the practice is that when a bill is passed and it is sent to the governor for his assent, it will always be accompanied by the advice of the Council of Ministers. Not a matter where he's left free to act. So the question is, in the context of the second proviso, I have already said that it is not binding. There may be cases where what the court laid down in the latest Supreme Court judgment is that there may be cases where the governor may entertain a genuine doubt that this is a matter which, having regard to its innate nature, must receive the attention of the president for his assent. It's a matter for another day. The court may have to clarify what is the effect of 1979 3 SCC, page 324 at paragraph 19, and 1974 2 SCC, page 831 at paragraph 123 and 124 of Justice Krishna Iyer's judgment. But the law as it stands today is that if the assent is not given, it is withheld, he is duty bound to act. The governor is duty bound to resort to the first proviso and to remit it back to the Legislative Assembly so that action is taken therein. This is the view taken by the Supreme Court, and as things stand, I think this is a law. I already, as a student of law, I was just wondering that when the first proviso to Article 200 says that when provided that when as soon as maybe a bill is presented, that the bill be sent back is what the first proviso says. I was wondering that when a bill once assent is withheld, will can you say that can you not say that the bill lapses, has been disallowed? But that is what has been laid down, as you know, in 793 SCC 324 in paragraph 19. But the court perhaps has not noticed this line of reasoning, both in 79 and the Shamsher Singh case. And this is the law as far as assent is concerned. I've already referred to summoning, addressing, discretion, now, I would therefore like to end by just referring to and reiterating, summarizing what is the position through the lens of the Constitution. The Constitution contemplates parliamentary democracy. First and fundamental thing, bear in mind. The governor is only a constitutional head. While he has certain powers, duties, and responsibilities, which he can exercise in certain enumerated circumstances which are well established, which I have told you, in all other situations, he is bound to act on the aid and advice of the Council of Ministers. He must not dabble in and indulge in politics at all. He must learn to remain aloof. That is one of the conditions, actually, of appointment laid down by the Sarkaria Commission. This is because, just imagine, in the space of 24 years, because Shamsher Singh was decided in 74, the court had to speak about remote controlling of the government. When it came to the judgment relating to granting of sanction, the tenure, which I have mentioned, the court has had to lay down that the governor is not a central government employee. He's not an agent. He's to keep aloof, and he's not to dabble in politics of any kind. He will impartially and fairly discharge the duties, not to carry out any program which the central government may have to topple a government and the circumstances exist for the exercise of jurisdiction under Article 356, the report being sent, one can understand. But he's not there for carrying out machinations, manipulations. He's there because the whole point is that the people of the state, of the country, are always watching these very high constitutional dignitaries. And that's why in the latest judgment of the Supreme Court arising from Punjab, the court said that the constitutional discourse must never degrade. It should not be a race to the bottom. These are the very words. It should not be a race to the bottom. There should be harmony between the governor and the chief minister. Both are high-ranking constitutional officers. But the chief minister is elected, governor is unelected. Each have their sphere, but the sphere of the chief minister, it must be realized, arises from his being responsible under a parliamentary democracy to the house and therefore to the people finally. It is his actions. He has to take responsibility for the successes and failures. The governor has nothing to do with it. Therefore, I would say that the governors must appreciate the scope of their power. I gave you the example of the Punjab case, where the governor did not even deem it fit to call the budget session, much needed budget session, and said that he is taking advice. These things have come to that kind of a pass. Then some of the governors say that the oath that they take obliges them to defend the constitution. I would only read one small paragraph from Shamsher Singh, where prophetically Justice Krishna Iyer has, in paragraph 118, laid down, dealt with this aspect. That was a case of a president. That case was a president, but then the constitutional person is the same. The argument about the oath of the office of the president to defend the constitution is sometimes put forward by anti-ministerialist advocates. Yes, he defends the constitution, not by denying its spiritual essence of cabinet responsibility. Indeed, he subverts it that way. But by accepting as his constitutional function what his responsible ministers have decided. Can a judge, in fulfillment of the oath of his office, ignore all binding precedents and decide according to the ad hoc dictates of his uninformed conscience? Tribhuvan Das answers the point in the negative. If every functionary who takes the oath by the Constitution interprets it according to his lights, this solemn document would be a source of chaos and collision, and the first casualty would be the rule of law. Such mischief cannot merit juristic acceptance. I'm only pointing out that the fact that the governor takes the oath, like the president, partly to defend the constitution, act for the welfare of the public or the state, does not entitle him to go overstep the limits of his authority. A constitutional body, as a legal body, must always first train himself in the law relating to what his authority to do what he wishes to do. Whether he is going wrong in keeping bills passed by the representatives of the people who are supreme, the people are supreme, and they choose their representatives. That is what the soul of democracy is. If bills are kept pending for years together, and finally, the parties are forced to go to court and look at the costs for democracy. A government is elected for a period of 5 years. The legislature passes laws. The laws are for public welfare, to attain public welfare. People, they deliberate, whatever the deliberation is worth. And the laws are made. The laws are to be put into force immediately. But if the governor, on a completely misunderstanding of the true scope of his power, or for other reasons, the reasons are, because right from beginning, the governor's office is, unfortunately, it has become politicized. In fact, this remark is made in the committee reports and in judgments. We have almost, unfortunately, if in the process of appointment, one of the suggestions made is that you should consult the chief minister of the state for which state you are going to appoint. So these conventions should slowly grow. In fact, Puji committee has made a recommendation for amendment of the constitution, as I amended Articles 155 and 156. There are all these laudable objects are actually put into play. They need to keep up decorum. I've already mentioned it, what the Supreme Court has laid down about decorum, the need for making decorum. Because, you see, in a constitution, in a democracy that we are living in, we actually inspire our rulers, and our rulers should inspire us. It is this mutual confidence building exercise which will go a long way to actually make render possible the evolution of a mature democracy, a responsible democracy, so that you put in place healthy conventions. And the constitution, as you know, cannot exist on the basis of the mere letter of the words used in the constitution, the words or provision used in the constitution. You should have constitutionalism, and this constitutionalism comes from knowledge and from eschewing ignorance and darkness. And I would therefore end by earnestly requesting all of you students to read these judgments and more judgments and reach your own conclusions. Thank you.
Thank you very much, sir, for this valuable session. അടുത്തതായി ഈ സെഷന് നന്ദി അറിയിക്കാനായി യൂണിയൻ അഡ്വൈസർ കൃഷ്ണകുമാർ സാറിനെ ക്ഷണിച്ചുകൊള്ളുന്നു.
Thank you. Respected dignitary of today's function, Honorable Justice K.M. Joseph sir, other participants who are present here. First of all, I would like to inform you that I was really excited to know that Joseph sir was to engage today's session. I have always followed his judgments and his individual standpoints and original comments, especially those on secularism. What was even exciting was the subject he spoke today. I want to say that as the session progressed, all of us were taken through the judicial process and the philosophical structure of the law of land. In this session, His Lordship has covered various areas like what are the powers and limitations of the powers of the institution of governor, accountability of governor, duty of the governor to consider and reconsider the advice of the elected members of the state assembly. So he has been taking us through a journey of knowledge. Sir, on behalf of all of us who have gathered here, on behalf of Government Law College Thiruvananthapuram and as well as on behalf of the College Union, thank you, sir. We express our sincere thanks, sir. Thank you, sir. Thank you very much.
Thank you. Thank you. Thank you.
മീറ്റിംഗ് അവസാനിച്ചിരിക്കുന്നു. സർ, എന്തെങ്കിലും പറയാനുണ്ടോ?
ഇല്ല. നിങ്ങൾക്ക് എന്തെങ്കിലും ചോദിക്കാനുണ്ടായിരുന്നെങ്കിൽ
ആർക്കെങ്കിലും എന്തെങ്കിലും സംശയങ്ങളോ ഒക്കെ ഉണ്ടെങ്കിൽ സാറിനോട് ചോദിക്കാം.
വൈകുന്നേരം 7 മണിക്ക് സംശയം ഉണ്ടാകാൻ സാധ്യത കുറവാണ്. So shall we call it a day?
Sir, good evening, sir. Can you hear me, sir?
Parayu.
Sir, my only question, sir.
Ah.
Actually, sir, what actually our constitution envisages the role of the governor? Is it a normal, so what is a remote control for a central government? Sorry, union government?
Certainly
Or
not. Certainly not. Certainly not. അതാണ് ഞാൻ പറഞ്ഞത് റിമോട്ട് കൺട്രോൾ പറ്റില്ല. അതായത് I indicated the judgment in the case which I gave you relating to the tenure.
Yes, sir.
There, you please read that judgment. I think it will give you complete answer about what is the the nature of the power which the governor has.
Right, sir. Right, sir.
Okay.
Right.
He's supposed to be dispassionate and remain neutral.
Yes, sir. Yes, sir.
He's not here to play. No governor is there to play politics on behalf of the central government. He cannot do that. Very
Right,
simple.
sir. Right, sir. Right, sir.
Okay.
Right.
Thank you. Thank you.
Thank you.
All the very best.
സെഷൻ അവസാനിച്ചിരിക്കുന്നു.